Good morning, everyone. Good morning. Welcome to XPX Philadelphia. My name is Mark Standering, Vice President, Morgan Stanley Wealth Management, and also President of XPX Philadelphia.
We're going to go into some of the ways in which people can put their estate plans in order. But just so the audience has a general idea, what types of documents should everybody have in place, regardless of whether they're going to go through a liquidity event?
Regardless of whether you're going to do any kind of advanced planning, you need some standard documents. You need your will, a revocable living trust. I like that structure, will, and a separate revocable living trust, an advance directive for health care, power of attorney. At a minimum, they would have to have those documents.
And one of the interesting things about what I'll call modern day estate planning is we've transitioned from the concept of relying upon a will for someone's estate plan, and we've now gone to using as basically the core estate planning document is a revocable living trust. Joe, do you have any thoughts as to why that's better than a will, a revocable living trust, for privacy, for probate?
Certainly, administrative-wise, it's easier. It's private. You read very few wills that actually dictate people's actions based on what they're going to be left.
Yeah.
Right. So that's the kind of in the purest sense. That's what trusts are generally used for. The fact that something is a little harder to contest, right? Yep. Although people contest everything nowadays, and that someone has to give a thought to it. Not to mention that in a lot of states it's cheaper, right? When you're probating through a trust as opposed to just your will. I can't think of any place where a will would trump a will and a trust.
Yeah. More recent famous stories is James Gandolfini, who was in The Sopranos. He was the lead guy, and he died a few years ago. He died with a will and no trust. Yeah. And there must have been 100 articles about his estate plan in every newspaper saying exactly where all of his money went. And if he just had a revocable trust, there'd be nothing to write about.
That's right.
There'd be nothing to report to the court. No assets to list.
Yeah.
Somebody has a liquidity event and they're going to come into maybe $80 million or some number like that, and they're suddenly realizing, once I get this $80 million, now I'm going to have to sit down and figure out how to give it away to the kids. What would you be telling, Joe, some people who hopefully are in advance of a liquidity event to do to avoid having to take the money and then wrestle with giving it away the day after?
The exemption currently is $5,430,000 per individual. Based on our calculation, come January, that'll be about $5,450,000. So they have that bucket, and if they're married, they have an additional bucket, right?
So that's about 11 million.
About 11
million that they could give away, right, without any gift tax.
So what we would want to do, and we would advise them, is, hey, let's talk to the valuation people and let's give something away before you get it, right? That's a hard conversation to have. All the upside inures to your child, right? So you give it away and you use $5 million to give away what 2 years later maybe, or a year later, or right after the transaction, maybe that $5 million that you give away using up your exemption is $20 million thereafter. Right? That's really the way to do it. It's very hard to convince someone to do that when they're selling their baby and they're getting finally the big payoff that they feel they and most assuredly deserve.
I find that more and more people are going for multi-generational trusts. And the purpose of that is twofold. One is that once you get it into the trust, and if you have a GST, generation skipping transfer tax exemption, that money will stay in the family for years without being taxed. The second rule is these multi-generational trusts have features of asset protection, so that the biggest concern a parent has is I'm going to give $20 million to my child. That should be everybody should have that problem. I'm going to give $20 million to my child, and he's getting married, and that's going to become a marital asset. And if he gets divorced, and if the divorce rate's 50%, there's a 50% chance that of that $20 million, $10 million is going with Betty to her next family. While if you keep it in trust, your child has use of the money their entire lifetime. It stays unaffected to go to your grandchildren. No tax when it goes to the grandchildren. So you can create a legacy with a multi-generational trust. I would probably say about 75% of the trusts I prepare are what we call dynasty or multi-generational trusts. But some people still say, well, you know, by age 50 they ought to figure it out. And I think the biggest problem we have is that the value of money changes. How you and I value money, Joe, it will be completely different than a child who receives the money by gift. And when that million or 10 million hits their bank account and they didn't have to work for it, I'm always amazed at how quickly it's spent. There's just not the same value of money. So we were talking about the need or the planning benefit of gifting some equity in a business before the transaction, and just focusing on sort of a family-owned business. One of the great techniques that the courts have allowed us to use has been that we can give away a percentage of a business and discount the value of it. And it's been just something that the IRS has fought for years. So maybe, Joe, you could tell us a little bit about the advantages of discounting gifts of family-owned businesses or family limited partnerships, and what the IRS announced just a couple of weeks ago they're going to do about this.
Yeah, so what Herb's referring to is generally a structure that we'll recommend, and most attorneys and accountants will recommend it, is a family limited partnership where if I own a business and I know the business is going to grow. It may not be sold, but I know it's going to grow in value and whatnot. I would take that or shares of that business and put it into a family limited partnership, right? Families limited partnership is what it is, but it's family because it's only family members. I would give each of my 3 children, let's say, a 10% interest. It would be a gift. It would be valued, right? That valuation, now because I don't own 100% and they own, you know, 30% in this family limited partnership, if it was $1 million business, my share now is worth 700, right? Well, what the IRS has said, that if it's in that family limited partnership, my share is not necessarily worth 700, because now whoever buys that has to deal with my 3 children who own 10%, 10%, 10%. So now I can die with this in my estate, and maybe it's discounted, right? It's discounted for estate tax purposes, and maybe it's only included in my estate for $500,000, right? If it was, we know it's worth 700, but now it's for estate purposes, and for the IRS it's 500. The IRS came out, and now they're going to start looking at that.
So just to illustrate the point, let's say the business is worth 10 million, and there's one child, and we give the child 50% limited partnership interest. Normally you would say, well, didn't you just give that child 50% of 10 million or $5 million, which happens to be under the exemption amount.
Yep. Mm-hmm.
and then the valuation expert takes a discount of, let's say, 25%, and the math is you get a discount of $1,250,000, so you're able to make that extra gift of $1,250,000 and not use up your exemption. So that's the kind of discounting that the Treasury Department says claims by the middle of September they're going to issue proposed regulations that will eliminate those discounts in family relationships.